Consequently, the Economy of Certainty, an introduction to the Typology of Islamic Legal Theory by Aron Zysow, Harvard University, 1984, Cambridge, Massachusetts. Chapter 1. The Unit Tradition. Despite the controversies with respect to the Mutawatir and Mashhur traditions, the heart of the usul treatment of traditions lies elsewhere. It is the unit tradition that is the focus of concern. The positions taken in regard to this sort of tradition are truly fundamental and serve as an infallible touchstone of the character of the legal thought in question. The basic division is between the formalists who recognize the unit tradition as the source of a valid norm but deny its certain authenticity, and the materialists who claim that they are the unit tradition, who claim that there are unit traditions whose authenticity is beyond question. The formalist position may be stated briefly. The most that can be expressed of a given chain of reporters is that each be of attested probity, adala, and exactness, dabt. That is to say, his scrupulous observance of the divine law indicates that he is not one to tell a lie, and his faculties are such not to render him suspect of some significant alteration in what he transmits. Yet, the possibility remains that men of this sort do tell lies and do commit errors. A unit tradition, consisting as it does of one or more several chains of this sort, can yield no more than a presumption of authenticity. Can it then serve as the source for a valid norm? The formalist answer is yes, provided that its presumptive authenticity is not rebutted. Such a rebuttal occurs under a number of circumstances, some of which will be treated below. These grounds for rebuttal may be said to be of a material nature, in that they are connected with the norm contained in the Hadith, with the content of the tradition. Distinct from them are the formal conditions which pertain to the chain of transmitters. These conditions concern the standards for probity and exactness which must be met by each of the transmitters, and the state of the chain in question, its completeness. Generally speaking, the Hanafis exhibit extreme tolerance with regard to these formal conditions, and this is so because they are so exacting when it comes to material conditions for validity. The materialists, for their part, reject the distinction between authenticity and validity. A source of law is valid because and only because its authenticity is certain. To admit presumptive sources into the law is to fall into the formalist camp, to relinquish the basis for opposition to analogy, and ultimately to shape God's law out of recognition. To realize their aim of building the law out of absolutely sound materials, the materialists need criteria for judging traditions which enable them to have certain knowledge and not mere presumption. These criteria they claim to possess. The Hanafis do not consider the epistemological status of the unit tradition problematical. The claim of the traditionists that it yields certainty, writes Fakhruddin Bazdawi, is false without a doubt, since common experience refuses it, or refutes it. They see their task as being to show that reason does not exclude accepting sources of this character as as norms for action, and that this, in fact, is what the divine lawgiver intended. We thus find arguments of two sorts, rational and traditional. We shall take up the latter first. Although there are some Quranic verses commonly cited in support of this position, the real foundation for the acceptance of the unit tradition as a source of law is the practice of the companions of the Prophet, what amounts to a consensus. This practice is considered to be so unambiguous that it virtually makes superfluous recourse to other normative sources, such as the practice of the Prophet himself, where there is also supporting evidence. But since the reports on which our knowledge of the practice of the companions is based are themselves unit traditions, the questions naturally arises as to whether we are not dealing with a vicious circularity. This difficulty is resolved by the notion of a concurrence in content. The stock examples of this are the valor of Ali and the generosity of Hatim al-Ta'i. Although no specific incidents in which these qualities are demonstrated have been reported to the degree of tawatur, nonetheless all the unit reporters taken together reach the level of tawatur and give us certain knowledge of the qualities in question. The same is claimed of the practice of the companions in regard to the acceptance of new unit traditions as standards of action. One can also cite the consensus of the nation of Islam to accept unit reports in their business dealings. This latter practice, however, is only analogous to the acceptance of unit traditions as sources for general norms. In any case, it is clear that the Hanafis felt no great difficulty in justifying by arguments from tradition the place of the unit tradition in their legal system. As might be expected, it is the rational arguments and the theological differences that make themselves felt. To conservative Bazdawi contents himself with pointing to the reliance put on presumption in the use of analogy and the decision of judges. For his student Samarkandi, on the other hand, the practice of the courts is only another example of the consensus of the nation to use unit reports in matters of legal consequences. The rational argument that he uses to support the acceptance of the unit tradition is not based on an analogy without any legal institution, but rather on the purpose of law in general. It is unmistakably Mu'tazili. Although only presumption is possible in the case of the unit tradition, not to act on this presumption would be to fly in the face of wisdom. To reject all unit traditions would undoubtedly mean rejecting some elements of truth. To accept them all indiscriminately would mean accepting falsehood. To refuse to do anything, tawaqquf, would also mean rejecting the truth. In all cases, one would be liable to the charge of folly. The answer is to make a distinction, and so one must act according to that which is most probable. For acting in accordance to that which is probable is part of the wisdom. This principle is common to all areas of life. It is obligatory to act according to the unit report in rational matters for an intelligible reason. That is also found in legal matters. The explanation of this is the following. We know by reason the obligation to avoid harm and propriety of gaining benefit when this is certain. Cases in which this is most probable are assimilated to those which it is certain, with respect to the obligation of avoiding harm and the propriety of gaining benefit. An example is the case of the man who has before him two roads and is informed by a person of probity that one road is secure while the other is infested with bandits. He is rationally obligated to act in accordance with this report, because warding off harm is the most probable result. Similarly, when a doctor tells his patient that his blood is in excess and he needs to be bled, he is obliged to undergo this treatment. Likewise, if one is sitting under a sloping wall and a man who has some knowledge of these matters tells him to remove himself, he is obliged to do so. In all these cases, he acts according to what is most probable, where action would be obligatory with certainty. What is most probable is assimilated to what is certain. The same reason operates in the divine law, for the law was instituted for the benefit of man. Its prohibitions are meant to lead to abstention from that which is bad, and which is attached to blame in this world and punishment in the next. The assimilation of what is most probable to what is certain is all the more necessary, because the harm in the earlier cases is confined to this world, but in the law it includes the next. Stay tuned for many more parts.